Could you distinguish what you mean by asset protection and estate planning? Aren't they essentially the same thing?
Well, it's often interconnected. So as a very obvious example, estate planning, which is concerned with tax and the disposition of one's assets during life and upon their death, often contains an element of asset protection planning. So my wife, as an example, is a physician. She's also a U.S. citizen. I could defer tax in my estate plan by simply providing that if I die survived by my wife, that all of my wealth passes to her outright. That would qualify for the unlimited marital deduction. But it wouldn't be a smart way for me to pass on wealth to my wife because as a physician, she has the very obvious risk of being sued for medical malpractice. So even though it's not necessary for me to control the wealth in her hands, for me to direct where it passes at her later death because our children are mutual, it's important for me to provide for her to receive her inheritance in a Q-tip trust because that will be protected should she ever get sued. By the way, it's also protected if she remarries and then later gets divorced, or if she remarries and stays married in order to avoid what's called the right of election that a future surviving spouse of my wife might have.
Well, those were great personal illustrations of why it's so important to not expose inherited assets to third-party claims, whether being pursued by the next plaintiff, creditor, or spouse. Are there other examples of when it's important to be concerned about asset protection?
Well, I think that the two situations where it's important are where a person anticipates or is concerned about third-party creditors, so as a lawyer, legal malpractice, as a doctor, medical malpractice, real estate developers, officers or directors of public companies, or I would suggest really anyone with wealth is at risk in this environment. The other situation that often comes up is people are concerned about the issue of divorce. So there's very little that one can do after they're married to protect themselves, but before marriage, there's quite a bit that a person can do, even beyond putting a prenuptial agreement in place. And for clients who are happily married, their major concern is that the inheritance that they've built for their kids shouldn't be at risk to the future ex-son-in-law or ex-daughter-in-law. And they're intelligent enough to recognize that if you've got two children, statistically one of them is going to get divorced. Now, I practice in New York, and in New York there's a rule of law that says that property that's received by gift or inheritance is separate property, which means that it's not available for equitable distribution to an ex-spouse. What my clients don't always recognize before we sit down and talk about this is that Connecticut, just as an example, which is the next state over, and where plenty of people move to, has a very different law. So while if your child stays in New York, their inheritance might be protected as separate property under New York law. If they move to Connecticut, there's no such thing as separate property, and their inheritance is completely available to an ex-spouse. And that's the law in a surprising number of states where people actually live.